The robots that could mine Mars are ready right now. The rocketry works, the autonomy works, the geology is mapped. And the reason the operation hasn't started has nothing to do with any of that. The machines exist. The landing systems have been tested. The minerals are there, locked in a rust-colored crust that's been sitting undisturbed for 4 billion years. So let's actually check what's stopping us. Not the engineering, the law. Let's read what the rules actually say, and then let's see how much of the legal structure is still standing once you test it against the physical reality of operating on another planet. Start with the treaty. The 1967 Outer Space Treaty is the foundational document of international space law, the closest thing humanity has to a rulebook for what happens beyond Earth's atmosphere. It was signed when the biggest players in space were the United States and the Soviet Union, and the dominant fear was that one superpower would claim the moon as territory the way European empires once claimed continents. The treaty solved that problem clearly. No nation can assert sovereignty over any celestial body. The moon, Mars, the asteroids, no country owns them. That part is airtight. Now here's where it gets interesting. The treaty forbids nations from owning territory. It says almost nothing about a private company extracting resources from that territory and selling them. That gap between you can't own Mars and but can you own what you dug out of Mars is not a minor technicality. It is a hole in the legal architecture large enough to fly a cargo rocket through. Two countries have already decided unilaterally that their citizens can own extracted space resources. The United States passed legislation in 2015 saying exactly that. Luxembourg followed. Their reasoning? The treaty bans territorial claims, not resource extraction. Other countries, most of the rest of the world, have not agreed to that interpretation. There is no international body that has ratified it. There is no binding treaty that says yes or no. The legal status of a kilogram of iron ore pulled from Martian rock and brought back to Earth is at this moment genuinely unresolved, and the companies closest to actually doing the mining have no particular incentive to wait for a resolution they might not like. Now let's test the proposed solutions against the physical reality, because this is where the legal arguments start to collapse one by one. The first proposal is national licensing. Your country issues you a permit, and that permit grants you legal ownership of what you extract. America and Luxembourg have done this. The immediate problem, a permit issued by one country is not recognized by every other country. If you land a mining fleet on Mars under an American license, and another nation, one that hasn't agreed to this legal interpretation, decides your operation is illegal, what happens? On Earth, there are courts, embassies, trade agreements, and ultimately the physical ability of governments to enforce their positions. On Mars, none of those mechanisms exist. There is no one to hand a court order to. There is no enforcement presence. The permit exists on paper. The mine exists on a planet that no enforcement body can physically reach. The second proposal is the Artemis Accords, a framework signed by more than 40 nations that establishes norms for resource use and safety zones around space operations. It's a real document, signed by real governments, and it represents the most serious attempt so far at an agreed framework. Now let's check the load-bearing beams. The Accords are not a binding treaty, which means they carry the moral weight of a handshake agreement, not the legal weight of law. They focus primarily on the moon, with Mars addressed only at the edges, and two of the largest space-capable nations, Russia and China, haven't signed. An agreement that excludes the second and third largest space programs on the planet is not a governing framework. It's a coalition of like-minded parties that has not yet been tested by actual conflict over actual resources. The third proposal is an international moratorium. Freeze all extraction until the United Nations negotiates a proper treaty. Let's run the timeline on this one. UN treaty negotiations move slowly. The Law of the Sea Convention, which governs deep-sea bed mining on Earth, took 9 years of negotiation before it was adopted, and the United States, the country most capable of deep-sea mining, still hasn't ratified it. Now apply that timeline to Mars. The countries with the fastest rockets and the most advanced autonomous systems have already invested billions. They have launch windows closing and competitors watching. The probability that those countries voluntarily pause their programs while slower-moving nations catch up in negotiation rooms is close to zero. A moratorium requires the cooperation of the people who benefit most from there being no moratorium. Here's the deeper structural problem. Every enforcement mechanism that makes Earth law actually work depends on one thing: the physical ability of some authority to show up. A judge issues an injunction because marshals can carry it to the defendant. A country enforces a treaty because diplomats, inspectors, and in the worst case, military forces can reach the location in question. Mars is 225 million kilometers away on average, which means even a signal traveling at the speed of light takes 20 minutes to arrive. That's one way. Send a command, wait 20 minutes. Receive the response, wait 20 more. 40 minutes for a round trip. Now imagine trying to issue a cease and desist order to a mining operation running in real time. By the time your injunction arrives, the machines have dug another 40 minutes of ore. By the time any physical enforcement presence could reach Mars, which requires waiting for the next launch window, a trip of 6 to 8 months, and a landing, the first miner could have been operating continuously for 2 years. That launch window point is not a footnote. The geometry of how Earth and Mars orbit the Sun means that the fastest transit routes only open up every 26 months, roughly twice a year, and only if you're ready to launch exactly when the window appears. Miss it, and you wait 2 years for the next one. That's not a delay you can resolve with urgency or funding. It's orbital mechanics. It doesn't negotiate. Which means the first actor on Mars doesn't just have a head start measured in months, they have a lead measured in years, because their nearest competitor faces a mandatory wait just to get someone there. By the time a second party arrives to contest ownership, the first miner has already extracted the resource, loaded it on a return vehicle, and sent it back toward Earth. What international body enforces a ruling on cargo that is physically in transit between two planets? There is no legal precedent for this. There is no Coast Guard for interplanetary space. There is no jurisdiction that physically extends to a mining site on a planet where no enforcement authority has any presence. The analogy that works is this: a judge in London issues a restraining order against someone standing in the middle of the Sahara Desert. The paperwork is real, the authority theoretically exists, but there is no one to hand it to and no way to enforce it before the situation has already resolved itself. So let's check the score. The engineering is ready. The legal framework has a gap at its center that no one has filled. The proposed solutions, national licensing, international accords, UN moratoriums, each fail when tested against the physical realities of interplanetary distance and orbital timing. And the people closest to actually mining are also the people with the least incentive to wait for anyone else to agree on the rules. The historical pattern is not reassuring. Every time humans reach somewhere genuinely new, the open ocean, Antarctica, the deep seabed, the same sequence played out. The first actors set the terms, extracted what was valuable, and everyone else negotiated around the reality that already existed. Antarctica got its treaty in 1959, but only after multiple nations had already planted flags and established bases, and the political map was already being drawn. The deep seabed got its convention in 1982, but the major industrial nations had already identified the mineral nodules they wanted and were already developing the technology to reach them. Mars will not be different. The question is not whether first mover precedent will shape the outcome, it's whether the legal architecture catches up before the first extraction, or whether the first ton of Martian ore lands on Earth and the legal challenge arrives years after the money has already been made. The treaty designed to prevent space from becoming a new frontier of territorial conflict succeeded at exactly that. It prevented nations from planting flags and declaring colonies. It didn't anticipate the next player, not a superpower, not a government, a private company with a fast rocket, a long-range plan, and no obligation to wait for a consensus that may never come. The rulebook for the most valuable real estate in the solar system was written before anyone knew the game would actually be played, and the game is starting.